presentation just to maximize my bandwidth. I hope that's okay.
That's okay.
Okay, thank you. And you can see my screen?
Yes, we can.
Okay, thank you, Anita. Once again, good morning, ladies and gentlemen. My name is Belinda. I have the pleasure of speaking to you on how to establish a data complaints management process within your business. The data complaints I'll be speaking to are those specific with the Data Protection and Privacy Act of Uganda. I would like to thank the Personal Data and Protection Office of Uganda for affording me this opportunity to speak to you guys. My task today is to share our experience by us, I mean Sanlam, as a data controller, protector, and collector on how we've managed to gel the process of managing data complaints, data-related complaints that originate from the DPPA Act into our normal day-to-day complaints handling procedure as a business within the services industry. And what we want to present is that we've not necessarily reinvented the wheel in trying to implement this process. In other words, we've not made any financial, resource, or technological investments that are specific to management of data-related complaints. My presentation will run through the subtopics on our journey as a data controller, protector, and processor. We'll also speak to the current complaint handling process that we have in place, and then we'll go further into defining the principles that guide us on managing data protection and privacy-related complaints. Then we'll also speak to the tools that we've implemented in ensuring we actually communicate this process, and then the importance of training and sensitization of staff. Then we'll also speak to some of the examples that we tend to see as complaints and how we will or we respond to those complaints. We'll also speak to recording of complaints and also the benefits that we see in having an effective customer data complaints handling process. Most of what I'll speak to is what we've already been trained on by the PDPO office in their various engagements. However, I'll try as much as possible to extract those actions that are deliberate towards creating a data complaints and handling process within the business. Now, our journey to start us off is that before we actually think about these complaints, there are certain actions that we've had to put in place, or certain things that we've had to put in place in order to preempt the existence of these complaints that are specific to the Data Protection and Privacy Act of Uganda. So action one is that we've had to appoint a data protection officer. Now, in terms of complaints, we believe that every service organization, or just even any other organization, has got that one person that is designated to receive, handle, and ensure customer complaints are resolved. In our case, we've designated the data protection officer to be a data complaint service manager or handler. Of course, this is on the premise that they understand the requirements of the Data Protection and Privacy Act of Uganda. Then our DPO also serves as an internal escalation point for data-related complaints. And in our case also, our DPO does not sit in the processing areas. Ideally, that those touch points where we collect, process, and control data. So that way, they are independent, especially in situations where you will have complaints that have to be escalated and investigated. So them being away from those touch points also offers an angle of independence, especially when we come to investigating data-related complaints. Anita and Becca, just let me know in case I need to make a stop for any comments or reactions or clarifications.
That is okay, Belinda, but I think we shall have the questions at the end, so you can go ahead with your presentation.
Okay, thank you, Anita. So action number 2, ideally, things that we will preempt to exist within our business before we even think about complaints handling, especially with complaints related to data protection and privacy, is that we've also ensured that the staff and agents within the business understand the existence of rights of data subjects. One thing you'll agree on is that the rights that are defined in the DPPA are very peculiar in the sense that they're telling you an individual has the right to walk to your office and demand to know the kind of data you have on them. This individual can also ask that you should delete any data that they feel you shouldn't have on them, etc. So with that, it's just not, you just don't take the assumption that people know that these kinds of complaints should be anticipated. So it's important that the staff and agents or any people that are at the forefront of the touch points where these data subjects come through are aware of the existence of these complaints and the rights that come with them having tried to exercise as well. Then we've also taken the initiative to assess our high-risk prone areas in the sense that you can't expect complaints. Okay, where you expect complaints, how ready are you to manage those complaints? So with that, when you do a self-assessment, you're able to see those areas of weaknesses that are within your business or your operations, which areas of weakness would then generate complaints for you as a data protector, controller, and processor. This self-assessment is the one that has been shared by the Personal Data and Protection Office. So it's a whole cocktail of questions just to keep you alert as to the requirements by the Data Protection and Privacy Act. Then we've also had to communicate, we've been deliberate in communicating that we actually anticipate these complaints from data subjects, and we've been open about it. Now, one way in which we've been advised to be open, and this is of course from the various engagements we've had with the Personal Data Protection Office, is through a privacy notice. So a privacy notice is sort of a transparency declaration of your data processes, how you store, what you use the data for, how you collect the data, etc. Now, the PDPO office has offered the kind of questionnaire kind of guide as to how you can, come up with a privacy notice. Now, our privacy notice is on our website, because the understanding was a privacy notice and its purpose as transparency is that it should actually be out there to the public, in that it should be accessible to anyone. So we've published that on our website. I don't know if people have had a chance to look at also other privacy notices that have been published by other individuals within Uganda as well. So the assumption is the privacy notice actually does communicate our commitment and our acknowledgement of the rights of data subjects, and that we are also ready and willing to actually receive complaints from data subjects. Now, as mentioned earlier, while introducing the agenda, we haven't really reinvented the wheel in terms of data-related complaints, in the sense that we do already have a service complaints process in place, being in the service industry. So we then go ahead and assume that the commitment that we have to managing the day-to-day customer service complaints is the same commitment that we are going to translate to managing data-related complaints. In any case, your data subject would ordinarily be a customer. And then over and above, there are also suppliers, there are also staff members. So it's the same commitment that we go along in assuming how to manage these complaints. Now, over and above the commitment, we've also come up with guiding principles that form the basis of how we are going to manage data-related complaints. Now, these principles are specific to data protection and privacy, in the sense that they do exist specifically for managing data-related complaints. So principle one is that we seek to see that any data subject that has a complaint, that involves us as a data controller, protector, and processor, they must find the comfort in coming to us first before they escalate to the Personal Data Protection Office or before they even go and blast on social media. So it's important that that communication of that trust is also key, and that the privacy notice as mentioned earlier has helped us achieve that. So we've made ourselves accessible through the privacy notice as mentioned. So we've declared ourselves as ready to receive these complaints. We've also sensitized our staff on being able to anticipate and expect these complaints, because like I said, the rights within the DPPA are very peculiar. So where your staff are not aware that an individual can actually come and make certain demands, they could actually either frustrate them or even ignore the complaint. Then we've also made our complaint process simple. So within our privacy notice, we've been able to declare the phone numbers with which you can make a phone call, the emails with which you can actually send an email to regarding any complaint, and then the need for a face-to-face conversation by declaring that we do have a data protection officer, and where there is need to actually get in touch with them, here is the desk phone number. You can actually get in touch with them directly. Then we also see that where you have a data protection officer that appears to be outside of the touch points, which are the controlling, processing, and collecting touch points, it offers a sense of independence when it comes to handling complaints, in the sense that a data subject wouldn't complain to the same staff that they've been in touch with and expect that their complaint will actually be escalated. So where it goes to your data protection officer, who appears to be independent, it also shows your commitment, to being able to handle these complaints, and also giving the data subject the comfort that they can actually complain to you and it's not a waste of time. Then we've also communicated our timescales within which we expect to actually give feedback to the data subject on their complaints. Then it's also important to acknowledge that the rights with data subjects are actually existent, and they're important rights to pay attention to. And therefore, in acknowledgement of those rights, you then anticipate that in the exercise of these rights, certain complaints will come through from data subjects as well. Now, principle 2 is that we seek to be deliberate and transparent in informing data subjects that actually we want to listen to your complaints. So that way we encourage them to keep coming to us. So with that, we've declared our complaints channels, the ones that are open to the public through email, through phone numbers, access to the data protection officer if necessary. Then we've also told staff to be able to explain these channels to the public or to the data subjects that we are in touch with. Then we've also thought to have that our data complaints process is open, and it's also available to individuals in as far as they want to get in touch with us. So making public the contacts of your data protection officer has gone a long way in that regard for us. Then principle 4 is that we envision that our complaint handling process should be fair and objective. Now, by fair, we want it to be open to all, and the privacy notice has made it easy for us in the sense that where the privacy notice is a declaration to the public, that means anyone can come to you and complain about anything. Then when we talk about objectivity, the existence of a DPO offers that comfort that where I have a complaint, I'm not going to raise my complaint to the same person I'm trying to complain about. So where your DPO is outside of your processing areas, it also helps in giving that independence when it comes to investigations, and also the fact that with some investigations, you'll actually have to provide feedback back to the data subject. Now, where feedback is very important is that when you go back to our principle 1, where we are saying data subjects should find it easy to come to us, to complain to us, you need to then provide feedback in that sense, because it then shows you're not actually taking their complaints for granted. Now, just to go further along, it's not enough for us to have the principles in place. It's important that you communicate your commitment to these principles, to the public and to your data subjects as well. So with that, we've developed 3 important facets that we use in communicating our commitment to having a data complaints handling process in place, but to also managing complaints that come through that are related to data protection and privacy. Now, facet 1, as mentioned earlier, is our privacy notice. This privacy notice provides information as noted under bullets 1 to 5 in the projected slide. Now, we anticipate that where you've made certain disclosures or where you've been transparent as guided by the PDPO office, you're able to reduce or eliminate certain complaints that will come through regarding your data process. Now, why that is important is that if you look at some of the rights that have been given to these data subjects, there is the right to complain should they feel that there's been an infringement or violation of their rights by a data controller, processor, or collector. So where you're able to be transparent by disclosing what you do with the data, how you store the data, where it's stored, etc., you sort of reduce on the complaints that may come through, or the questions that may appear as complaints that may come through for you with the data subjects. Then facet number 2 is that where it is possible for us to get in touch with the data subjects, especially through physical interaction or interfacing physically, we've been deliberate in having this conversation with the data subjects. So these are instances where maybe you're processing a claim and you're able to get in touch with the data subject. So you have documents that are declaring your commitment to data protection and privacy. Then you have insurance contracts, then you have staff contracts, you have supplier contracts and all. So at that moment in time, where you're having that physical interaction, it's an opportunity for you to explain your complaints handling process in place, and to also direct your data subject back to your privacy notice and just let them know these are the channels we have in place should you need to complain or should you need to exercise any of the rights as stated in the Data Protection and Privacy Act of Uganda. Then that opportunity of physical interaction also gives us the opportunity to have the consent that you so require as stipulated in Section 7 of the Act, where you're required to have consent to collect or process personal data of a data subject. So remember, it's important that this consent is explicit, in the sense that it's been signed off. You can clearly see that the data subject actually gave you the consent to collect and process their data. So it's in that physical interaction that we then get that sign off and then get them to understand what it means for them to give us that consent, so that in the event you have complaints, at least that was explained at the point when you actually did get that consent. Yeah. Then facet number 3 for us seems to be a very, very important facet, and that is of staff. Now, we do believe that any effective complaints handling process will always involve human beings, in that case being your staff. So with that, we also believe that before you actually have, in managing your complaints handling, you need to have a few soft skills. And these soft skills, of course, must be presented by staff as well. So you're looking at being able to listen or communicate appropriately, being humble, showing some empathy towards data subjects, being compassionate, and also being creative in how you solve complaints or how you resolve complaints that have been highlighted by data subjects. So, because at that point in time when the data subject is actually complaining, they're angry, they are grieved. So, these soft skills come in handy. But over and above that, there are certain criteria that we have in place from the ordinary or the day-to-day complaints handling process that just deals with the normal complaints that come through the business. We do have certain expectations as projected on the slide that we set on our staff, be courteous, be professional, be responsive, demonstrate integrity, and then respect the confidentiality of the data subject. Now, these are your more day-to-day, they're inherent within your existing customer complaint process as a service department. As a service company. However, it's just not enough to have these expectations and to also expect that these soft skills will come in handy. It is important that your staff are aware and are trained on the Data Privacy and Protection Act of Uganda, because where staff is not aware, or they don't have the awareness of what to expect, then you're not sure if they will actually be able to welcome these complaints in the first place. Then you also keep it at the back of your mind that your staff will usually be the drivers of the conversations around data protection and privacy, because they are at the forefront. They are the first people you find at the collecting, processing, and controlling touch points. It's therefore important that they are aware of what to expect, because naturally they will then be the first receivers of any complaints, either informally or formally, any complaints coming through from the data subject. So it's important that they are aware of the specific requirements, of the specific rights that have been set out by the Data Protection and Privacy Act of Uganda. That way, it is not absurd when they hear some of these rights. And like I say, these rights are not usual. People can come and ask for you to erase information you have on them. They can come to demand to know how you store their data, how you process their data. They also have the right to come and ask you to, change, just confirm what kind of data do you have on me. So that's not really something you're used to, especially in the service industry. But now the law is telling you, yes, they do have the right. So your staff must be aware of this. That way they are willing to accept, and they're willing to listen and also understand and manage, where possible, any complaints that are coming through. So I will be speaking to some of the benefits you will get from training your staff. And these benefits are just specific to how you manage your data protection and privacy complaints, related complaints for that matter. Number one, while your staff are trained, then they are confident. They know what to expect. So where a complaint comes through, they are not defensive, out of ignorance or out of not knowing what to do, So they are aware, and they've been told to expect, and they know what to do. Then under the other benefit that we see is that knowledge received through training also helps staff to respond quickly You know, at that point when your data subject is complaining, or they are aggrieved, or they just want to challenge you on some of these rights, it's important that they get the impression that they're being heard, they're being acknowledged, and that their complaint is being taken seriously. So in that moment in time, you also want to be able to be in charge of the response of the data subject. In other words, you want to be able to explain and come out as competent in understanding their rights. That way, they don't escalate, or they are not aggravated by your lack of response or lack of knowledge of what they are talking about. You know, so and that is also very important, because it keeps taking you back to our principle one. You want your data subjects to come to you first, to trust that, you know what, they can come to you as a data controller and protector first, before they run to the PDP, or even before they run to social media. Then we also see that training staff, you know, equips them to think in terms of solutions. Now, why that is important is that the Data Protection and Privacy Act is a new act for Uganda. It's barely 3 or 4 years old. So with that comes that understanding that not very many people understand it. Now, the fact that there are rights, the rights will have to be exercised, whether people understand the rights or not. So you as a data protector, controller, and processor, it's important that in that moment in time, when someone is complaining or someone is aggravated, at least you have a solution. So these complaints will come through different forms, you know, so not all data subjects will complain the same way, and not all of them will interpret the rights the same way. So where your staff are equipped with the knowledge on what to expect, you know, they are able to tailor the conversations to the situation at hand, as and when they are faced with these data related complaints. Then they also know, because through knowledge, they also know where a situation is outside of their control, it's beyond their control, and they now at that point in time need to escalate to the data protection officer of the business, as opposed to appearing as if they don't understand what the data subject is talking about. Because what you also need to keep at the back of your mind is that the data subject is also free to walk to the personal data protection office and challenge you on these rights. Yeah, so it's not always that just because you ignore them, they can always stop there. It's easy for them to actually walk to the PDP or even social media to make it worse and just make noise about how you've breached their rights, so you're not controlling or managing their data well. Then we also see that the benefit that comes with training is also, you know, for staff, you know, getting to know these rights deeply. Now, it also helps that staff are also data subjects. So it's a two-edged benefit for them. They're able to advise data subjects, and they're also able to understand their own rights as data subjects as well. Then, like I mentioned, these rights are quite unusual, you know, for a service company, especially, you know, any servicing company anyway. So for someone to come in and demand that, say, you know, stop collecting data on them, you know, tell me what kind of data you have on me, I would like you to erase the kind of data you have on me. It's quite an unusual experience in a service relationship. Yeah. So where staff are made aware, then they know how to respond, because what is important is that sometimes data subjects will come and challenge you and present a perceived breach of rights, you know. So your staff, if they know these rights and they're able to check the situation within their own control, and you know, they can easily explain what was perceived as a breach of rights, you know, to easily, then that way you avoid escalating the matter to the PDP or to social media. So it's very handy. It comes in handy where your staff at the forefront are actually aware of what to expect and you know how to handle data subjects. You do have a data protection officer, yes, but what if they're not available in that moment in time? What if they're faced with an angry data subject or aggrieved data subject, or even a data subject who doesn't understand the law, and they just need time for you to check them through, just so you can convince them, just so that you can actually gain that trust from them that, you know what, they actually, you're managing their data well, and they can come to you should they have any questions or any complaints or any concerns regarding their data, which takes us back to principle one. They should find it easy to always come to you first before they go to anyone else. And that creating that environment is very, very important for you as a data protector, collector, and processor. Now, we've also highlighted some of our responses or perceived responses to what you'd call, you know, the complaints that may come through as complaints through a perceived breach of any of the rights as defined in the Data Protection and Privacy Act of Uganda. Now, what we seek to do is that we ensure that our responses to these complaints or perceived breaches are consistent and action-oriented, you know, towards convincing the data subject that there's actually no breach. and there's no need to escalate outside of the organization. So the assumption is where the rights are there, people will choose to exercise those rights or not. So it's easy for them to assume a perceived breach of right, especially where things are not clear. And remember, the law doesn't, the data subject doesn't have to wait for you before they escalate with respect to the law. They can walk to the PDPA office. Worse still, they can walk to social media and misinterpret a situation. Yeah, and there is your name being dragged in the mud for breaching someone's data protection rights. So with that in mind, we are therefore very deliberate in how we manage these complaints, in the sense that we avoid having a perceived upper hand. By a perceived upper hand, I believe that superior, corporate knowledge of, I know it all, that data subject has got nothing on me. They don't know what they're talking about. Because any sign of arrogance or superior attitude can be misunderstood as you taking advantage of the data subject, especially in cases where the data subject does not grasp the law so well. Or worse still, it can even be taken as an infringement or violation of the data subject's rights. So with that, it helps to be humble, but also to always be in control of the situation, and to always take you back to principle one. They should trust you. They should be able to come to you with complaints. So what you have projected on the screen are example or sample responses to complaints we anticipate that will generate from exercise of the rights by the data subject. So if you're looking at right one, the right to object to collection of their data, if this objection does not in any way create a non-compliance to other laws. Now, as an accountable person, especially with respect to the Anti-Money Laundering and Combating of Terrorism Financing Act, you'll be quick to defend why you collect the data, because the AML law requires that you actually collect data and identify your customers. However, you remember, at that point in time, your customer is agitated, they're angry, they probably believe they have a right and they're willing to exercise that right. So taking control of the situation requires that you don't defend yourself as a data controller, processor, or protector, to avoid aggravating the customer or the data subject. So with that, you then point out the need that is actually in the best interest of the data subject. Now, when you look at the legitimate interests that are provided for within the general requirements of the data protection and privacy, you do have different interests, but there are those interests that are just specific to the data subject. So in this particular case, you do have an existing contract, which in our case would probably be an insurance contract. So I would respond to the data subject by letting them know that I'm collecting this data just to assist me be able to service my obligation with respect to the insurance contract that I have in place. So this way I'm able to tailor the response to the data subject's interest, i.e. being their legitimate interest as the other party to the contract, because it doesn't help in that moment in time to then assert my position as a data controller who is also an accountable person as per the AML Act, because the data subject may not even understand your AML Act, yes. And it doesn't mean that just because you have an AML Act, they don't deserve to be told what their data is being used or collected for. Now, with right to withdraw consent to collecting, processing data, as long as this withdrawal does not in any way affect our compliance to other laws. So we would give the same response as we had in number one. We still give a response that is tailored towards making the data subject believe that it is within their interests that we are actually collecting this data, and it's not, we encourage them not to withdraw, because like it says, it is their right. So like I said, it's important that you create the principle one. They should trust you, they should be able to come to you, and they trust that you have their best interests at heart. So it's just not about asserting yourself as a corporate business, Then if you look at right three, right to complain to the PDPO or NITA if they find that we are processing their personal data without the appropriate security measures. Now with this, I would assume that where the data subject would like to complain directly to the PDPO, you cannot stop them, in as much as you've been able to disclose how you store your data and what you use it for, and any, cyber-related incident or preventive measures that you put in place, they still can go and, escalate to the PDPO. So what is important at that point in time is where you have such a complaint, you must then support the fact that you're able to recover lost data and that you have security measures in place to prevent any cyber-related incidents. Then if you look at right number 4, right to report a data controller, processor, collector who has gathered inaccurate data on the data subject. Now, I'll take you back to at a point where I talked about consent. Now, consent is very important in the sense that it is, in my opinion, for me, it's the holy grail in collecting data, in the sense that the legitimate interest where it comes through consent is very easy. But even then, a data collector cannot, a data subject can then not challenge you on so many angles in terms of the wrong data you've collected, etc. So where you're able to support that the data you have on the data subject is that was given to you with consent at that point in time where the data subject actually allowed you to collect their data, then you're able to actually cover your back in that instance. Now, we both know consent is not something easy, but in as much as possible, I think it's one way. It's one way in which you can cover yourself in terms of certain complaints, but even then, the law requires that you actually get this consent before you collect data. So where it's possible, please get that consent, because it does help you avoid some complaints or some instances where matters may be escalated to the PDPO and you do not have a defense for yourself as a data collector, controller, or processor. Now, I'll be speaking to right 5, the right to complain to NITA of any infringement or violation of the Act by the data collector, controller, or processor. Now, when we speak to the privacy notice, you realize that the transparency that you have within the privacy notice discloses a lot, in the sense that you're able to deal with certain or perceived infringements or violations by data subjects. Why that is important is that you're able to preempt certain discussions around data by disclosing this information. So the right to complain of any infringement or violation will not be as blanket as that. So certain items that you've disclosed within your privacy notice are able to help you avoid these kinds of complaints. So Becca, I don't know if the understanding is that everyone knows what a privacy notice is. I don't know if there is need for us to speak to a privacy notice after we are done with the presentation, but it does disclose quite a lot. But like I mentioned earlier, the compliance self-assessment that has been set out by the Personal Data Protection Office of Uganda gives you subject matters on what to disclose within your privacy notice. So just take some time and have a look at that. Now, even like I mentioned earlier, transparency also earns you that trust from the data subject for them to know and for them to confirm that they can actually come to you first before they run to the PDPO, before they run to social media. That concludes the examples we have. We'll probably discuss further within the discussion time allowed. Now, I would like to speak to the record of data complaints. First off, you realize that the annual compliance report that we'll be submitting to the Personal Data Protection Office requires that we have a record of complaints that we've handled as a data controller, protector, and processor. So with that comes the need to record these complaints. Now, just to highlight, given the significance of the rights that exist within the law, it's important for us to be aware of every data-related complaint that we receive. And that is why we assume that every data-related complaint should be considered a significant complaint, in the sense that you give it the attention that it requires in order for you to sort or resolve the matter and give feedback to the data subject, and within the stipulated time as highlighted in your privacy notice. Therefore, we are very keen on following up on data-related complaints, simply because we don't want data subjects to escalate without giving us a chance to solve the complaint internally. Now, the only way you're going to be able to keep in mind or keep track of how far you've gone in solving these or resolving these complaints is having a record of the complaints. Because what you don't document, you may not remember or you may not know. Now, of course, the responsibility for documentation and for resolving and then checking and keeping up with the status is left with the data protection officer of the business. Then the benefit you'll also get from recording is that you're able to assess the kind of complaints you're receiving from data subjects. That way, it sort of gives an insight to any weaknesses or gaps that you may have within your data handling processes, or any improvement solutions that you may have within your data handling process. then you also realize that as a DPO, where the responsibility is yours to then manage the data protection and privacy regime within the business. Complaints also give you an insight as to how to improve your controls within your business in order to avoid these complaints from recurring. So it's important that you record the status of each complaint. Now, the compliance, the annual compliance report requires that you have a status of the complaints you have received, those you have resolved, and those that are pending. Now, the only way you're going to be compliant to that particular requirement is if there's a record, record of what you've received, what has been resolved, and what is pending, and probably why it's pending. But also the important part is where you have a record, then at least you have it at the back of your mind, what complaints are pending resolution with the data subject. Like I keep saying, the data subject has the right to complain if they perceive a violation or infringement of their right. So where you have a record, it's then easy for you to keep going back and then just affirming to yourself that, yeah, you have dealt with this data subject, you have affirmed to them that you're dealing with a matter, or you provide any feedback, whatever it may be at that moment in time. Sorry. Now, I will be speaking to the benefits that we've seen through having a clear complaints handling process. Now, the biggest benefit for us is the trust in the process by the data subject. And this trust comes with transparency and communication, which of course is the underlying, which is of course governs the underlying principle number one, that data subjects afford you the opportunity to address their concerns internally before they escalate to the PDPO or before they run to social media. Then with a clear complaints handling process, you're able to manage risks, because not managing complaints properly is just not about data protection and privacy. It also escalates to your service, because in most cases, most of your data subjects are either customers, they are staff, and they are also suppliers in most cases. So it helps you manage any other risks that may arise from poor handling of data complaints. Then you also look at the reputational benefits. With the reputational benefits, of course, it goes without saying that in exercise of these rights, someone could get hurt, and that someone could be you. And that is the data protection and data controller, protector, and collector, in the sense that if this aggrieved party went straight to the PDP or stormed social media with all sorts of allegations, and sometimes they may storm social media without the facts at hand, or without even understanding the side of the law, or the side of the angle of you as the data collector or processor. So it's important that you're able to manage them, in-house, to avoid things escalating out of hand, especially within the media. Then you also keep it at the back of your mind that where your data subject is inherently also a customer, managing a data complaint poorly could actually result in termination of the primary service contract in place. Now, for our case, that could probably be the insurance contract. So it's important to see those benefits from that angle as well. So that is why it's very, very key in managing your complaints and having them clearly documented as well. That way you're able to keep track, provide feedback. Because like I keep saying, principle one, they should trust that you're able to actually handle their data complaints, and they're also in position to receive their data complaints, and with a good heart, or their interests at heart for that matter. So Becca and Anita, my presentation was short. With that, I conclude my presentation, and I hope that I've been able to shed some light on how you can establish a data complaints management process to the audience online. And with that, I don't know if Becca should speak to the privacy notice further, or just give an example of what it looks like. And with that, welcome any comments, questions, and reactions. Thank you very much.
Belinda, please go ahead and speak to it. Thank you.
Okay. Thank you, Becca. Just allow me to unshare this slide and then share something else. Thank you. I don't know if everyone can see my screen.
Yes, we can.
Okay, thank you, Anita. So this is what I've been referring to as the privacy notice. So as explained, the subject lines defined in the privacy notice have already been defined in the compliance self-assessment that has been set out by the Personal Data Protection Office. It's an Excel that Becca shared a few weeks ago, so you could probably get in touch with him to just get a copy and see what it looks like. So your privacy notice, like I said, should be made public in the sense that everyone should access it. So the easiest way currently right now is through internet. So this privacy notice is posted on our corporate website. So we've also gotten shared links on how to directly access it. So these links are shared with staff, which staff then share with data subjects or any intermediaries or agents around. So the privacy notice in itself just describes what you do with company data. And over and above that, what is your commitment to your data subjects and to their rights as defined by the Data Protection and Privacy Act of Uganda. So so you have detail like how we collect your information. And like I said, this is just part of being transparent to the data subject. And in being transparent, you sort of allay certain fears that could come from a perceived breach of rights for the data subject. So how we collect information, directly from you, indirectly from your intermediaries, etc. Then collection of information by third parties. Of course, in our service industry, we do have third parties that we engage with. So we also acknowledge that once in a while, we'll go to those third parties to collect information about you. Then what kind of information we collect and what we use it for. So in cases where you're faced with a data subject wanting to know what information you have on them, when they come to read this privacy notice, at least at the back of their mind, they know what we've collected on them. And, at least they come from an informed point of view. So being transparent sort of also takes away the pressure of having to explain yourself over and over again, or even explain yourself every other time. Because this is made public, everyone should be able to access it. Yeah. Then you also talk about how we use your information. This speaks a lot to management of the insurance contract, but also in terms of other laws that require we identify your customers. So all that is disclosed here. Then who do we share your information with? Then do we transfer your information across borders? How do we store? What security programs do you have in place in order to keep your data safe? Then we speak to the rights as well. Now, these rights, of course, are within the law. Now, you speaking to them acknowledges that they actually do exist. Then we've also noted that where you wish to exercise any of these rights, please reach out to us as Sandler. Yeah. Then we've also talked about marketing and then the need to also, take you out, because you also expect complaints to come from direct marketing, because the law is very clear on direct marketing. So where we may unknowingly send you information that you believe you don't want to have, you have the opportunity to come back to us and opt out of that. Now, that's one way of managing that complaint, because where you keep sending and the client then escalates to the Personal Protection Office of Uganda, you have given them a leeway as to how they can come to you and tell you, what, guys, I need to stop receiving these direct marketing related, messages or SMSs from you. So there's quite a lot we disclose. Then you also talk about questions regarding this statement. So with that, you then have the details of where you can actually go and and escalate your complaints as well. So these desk phone numbers are the direct desk phones of the data protection officers within the two Sanlam companies that sit in Uganda. So Becca, I don't know if there are any questions to the privacy notice. And I think with that concludes my presentation. So I don't know if there are any comments or questions or reactions that I need to speak to.
Thank you, Belinda. I hand over to Anita to take us through with the Q&A session.
Thank you very much, Becca. Thank you, Belinda, for this wonderful presentation. Members, it's very important to have a complaint handling system, and also most importantly, please ensure your staff are trained about the data protection laws, and of course, not leaving behind having a privacy notice. Belinda, it has been really a great learning experience for me personally, and I believe for the rest of the members of this call. For the questions, Becca has been able to respond to most of them. Thank you, Becca, for responding to the questions. So I do not see any new questions. Members, I have posted a link on the chat. This link is basically to the evaluation form for this webinar. Kindly click on it and provide us with feedback about this webinar. The reason we are doing this is because we need to be able to serve you better in our other webinars. So I am going to invite Becca to come and give us the closing remarks. Thank you.
Thank you, Anita. Thank you, Belinda, for giving us insights on your process of handling complaints using existing mechanisms in Sanlam, and also giving us examples and how it can be done. We've been getting a number of questions since this is a requirement of the law, how one can set up a complaints handling system, and given very good examples that you can use already existing mechanisms to be able to handle the complaints, and of course, increase the trust of the people from whom you collect the information. And then also about the privacy notice, it's good you highlighted, because we realized most of complaints about either sharing or marketing, people not understanding how you collect and use the information. And this can be cured, as you pointed out, by having that much information detailed in the notice and making it available to the different parties. So thank you for highlighting that. So you've also talked about that, recording the benefits of these complaints and what they feed into. So my colleague will come and talk to what is expected to that. Will give us very brief an announcement in respect to what we expect about the record of complaints. But once again, thank you for sharing your experience, Belinda, and we look forward to engaging with Sanlam more in regard to creating awareness, even beyond just handling of complaints. And thank you to our participants, people that have been able to stay online close to now an hour. Okay.
Thank you very much, Becca, for the opportunity as well.
Okay, you're welcome. I believe the rest have been able, to learn from it, and they'll replicate it, the DPOs, in their organizations. So allow me to invite Ian to make an announcement and we close. Thank you. Ian works with us, Ian Solomon Obo from the Compliance and Investigations Department. Maybe as Ian comes on, please complete the survey, because that's the only way, like Anita said, we can give you better training to know what went well, what could be improved, or what we can emphasize. It's in the chat. Over to you, Ian.
Okay, thank you very much, Becca. Thank you, Belinda, for the presentation today, and thank you, Anita, for moderating. Good morning, ladies and gentlemen. Excuse me. Like I was already introduced, my name is Ian Solomon Obo. I work under the Compliance and Investigations Department of the Personal Data Protection Office. I cannot overstate how timely this specific topic is, considering that a good complaints handling system, which recognizes personal data complaints as significant, like Belinda ably stated, plays an important role and eases your obligation as data collectors, data controllers, and data processors to submit the annual compliance report. Like Becca said, mine is just an announcement and a reminder that this annual compliance report, as directed under Regulation 50 of the Data Protection and Privacy Regulations, must be submitted between 1st July and September 28th of every calendar year. I'll just repeat that. 1st July, it must be submitted between 1st July and 28th September of every calendar year. There will be a follow-up email that will be sent to all data protection officers of registered data collectors, data controllers, and data processors. That will include a template of the annual compliance report. But also to state, this annual compliance report will be, upon completing it, it will be delivered in hard copy to the National Personal Data Protection Director. That will be the address, that National Personal Data Protection Director. And it will be delivered to the physical office of the Personal Data Protection Office, which is at Palm Courts, Plot 7A, Rotary Avenue, which is usually referred to as Lugogo Bypass. Thank you. for this opportunity. I thank everyone who has been part of this. And I also thank our presenter. And we hope to hear from you more often. Yeah, over to you, Anita. Thank you so much.
Thank you very much, Ian. Ladies and gentlemen, thank you for attending this webinar. Till next month, have a wonderful day.
Thank you, Anita. And thank you
Thank
to
you so
everyone.
much.